Can you guys believe it? This is the last eviction hour of 2024. Where did the time go? Hey there, it's Christian Walsh with Wire Associates and my buddies Kenny, Zach, and Raphael. We are here for eviction hour. Now, usually I can say I can't give tax or legal advice, but you can get legal advice from the guys in ties. Kenny's not wearing a tie. It's casual Thursday in the office, I found out, and only Kenny apparently sent that memo to himself because
Only I
you
got that.
guys aren't casual. So,
Yeah.
so what's going on, guys? How you doing?
Good. How are you, Christian?
Good. So, Michelle's in the background. She's going to make sure everybody keeps it clean for the most part. I guess there isn't much to keep us clean, but anyway, got a lot I want to cover for this last one of the year. But a very important thing to dive into first, for those who tuned into our last episode, it was just before Thanksgiving, and Zach and his family were going to do a gingerbread competition. And this is not your normal, like, buy a kit and slap on some gummy drops. Like, this is legit. Zach, how'd it go? Give me an update.
Went great. So
There you
we
are.
did, I think the theme was art around the world. We decided to not be in Kansas anymore. We did the Wizard of Oz, like, for Wicked. I don't know if you saw that. I loved it. And
I loved
so
it.
we had Mike and Ike's we used to make the Emerald City and the Yellow Brick Road. What do you call him? The straw man or the scarecrow guy out of pretzels, and used some licorice to make the ruby slippers on the Wicked Witch that gets crushed by the house. We won. We have a lot of categories that are just there so you can give pity points. So I think we won the People's Choice. We have like Best in Show, People's Choice Award, Lifetime Achievement Award, every kind of award, because everybody has to get one award. So so it was an okay year. My wife is infinitely more talented than I am, but that's what we went with.
Is there a best taste? Does anybody actually eat these gingerbreads or what?
No. Yeah, we were always like it would be kind of gross. I think we use almond butter to glue everything together, and the taste would just be monstrous. So
I have to tell you, I couldn't wait to get that update from you, because you really set that up going in, and it sounds like it was everything I dreamed and more. So
yeah, I'll have to get you pictures. It's like we got a million zillion of these pictures of all the different creativity and whatnot. This year, not my best work, but ready for next year. Already planning for next year.
I can't wait. All right, so we're going to dive in. So there's a few important things I want to talk about. But I want to get everybody set up for 2025. So we'll talk a little bit about that. But first, some people actually posted some questions under the community post. So let's go ahead and take care of those folks, because they were A students. They get a gold star because they actually gave us something to talk about. So let's start with the first one from Soulboarding. It says, can you explain the process of just cause evictions under AB 1482, where the landlord plans to do a major renovation with permits? What's the expected time frame to win, and how much it might cost the landlord if it goes to jury trial? So before you guys dive in, to clarify, if you do terminate the tenancy for a major renovation, you're going to deliver the permits to the renter ahead of time with the appropriate notice, whether it's 30, 60, or 90 days, and you owe 1 month's rent for relocation assistance, unless it's in a municipality that has more strict rules or more requires more relocation assistance. So the only time you'd go to court in this scenario would be if the renter does not move out after that appropriate notice. And I'm handing the mic to you guys. Take over.
Christian, you covered it, in a really good, excellent job explaining the process on how to get to court. And as far as how long these substantial renovations cases take. I guess it depends on which courtroom the case is filed in. Also, what kind of tenant you have. If the tenant could be extremely litigious, it could take longer, or if the tenant wants to settle quicker, it could be shorter, right? Also depends on opposing counsel and also the time of year you file. For example, if you were due to be in court sometime in the next 2 weeks, your case is most likely going to be continued because it's the holidays, right? So that also affects the timing of cases. And
That's good insight right there, by the way, Raphael. I appreciate you sharing that. So a lot of cases this time of year just get pushed.
Right, they get pushed, and also it's actually the most common question we get: how long does it take? Right, how long is eviction going to take? But it always depends. But generally speaking, it's 2 to 3 months. Right. I mean, most of the cases get resolved in that time frame.
And there's nothing special to the substantial remodel termination of tenancy. You obviously have to follow the process correctly. So that's what you guys would double check before taking on a case like this that's going to a UD, unlawful detainer, is you guys would double check, make sure that the permits were delivered, appropriate notice, relocation assistance. So if that's all taken care of correctly, there's nothing particularly special about this eviction, correct?
Yeah.
Except that, sorry, okay, but except the fact that unlike a regular eviction, you would serve a 60-day notice. So it does add 2 extra months, right? So there's also that. So
well said. Yeah, to the beginning of the process, correct. Yeah. This is if they don't move out. So yeah, that's a very good point.
Yeah. So just to add on to that really quick, Christian. So I think a common misconception that a lot of people have when it comes to evictions is that depending on the kind of case it is, the courts will look at it differently. That's not the case. An eviction is an eviction, regardless of what kind of cause of action you're bringing forward it under. So whether it's non-payment of rent, whether you're doing a renovation, whether you're doing a tenancy at will, they're all going to be an eviction. And you have to bring a lawsuit forward, and the courts are going to get to them based on where they are in the litigation process. As Raphael mentioned before, typically if it's an uncontested case, you're probably looking at 2 to 3 months. Even if it's a bench trial, you might be looking at 2 to 3 months. But it's going to be dependent on the time of year that you file, along with basically whether or not they ask for a jury trial or not. The other thing that I want to point out is the right to a jury trial is basically given to either party. If one party wants a jury trial, they have the right to a jury trial. And there's procedural hurdles they have to get over to get to that point. But if the other side wants a jury trial and we don't, or the other side doesn't, the side that doesn't want it can't unilaterally say, well, let's just do a bench trial and screw your right to a jury trial. If one party perfects the right to a jury trial, they have the right to waive that or not, and the other side can't do anything about that. So that's something that I wanted to point out, is that a lot of landlords want to say, well, why do they have to do a jury trial? I want a bench trial. Well, based on the California Constitution, we can't do that right now. One last thing about this substantial renovation as well. I do want to point out that judges, for whatever reason, tend to disfavor these kind of cause of action, and they'll be very, somewhat. They'll add a little bit more scrutiny onto these cases. So although you might meet the minimum barriers in terms of what the law says, in terms of proving your case, saying you have to pull the permits, you have to serve the 60-day, you might have all of that there. But then the added element of credibility, the added element of actually being able to show that you're going to do this essential renovation is something that is going to be left up to the judge or the jury to decide. And so you as a landlord, if you really are considering doing a substantial renovation, you really need to come prepared. You need to come with the receipts. You need to show up and say what exactly it is you're going to repair, why is it you're going to repair it, and really mean that you're going to repair it and actually do the renovation. You can't just sit there and say, oh, well, I'm thinking about doing it. I thought I should do it. You need to actually be doing it. And courts are going to, really hold you to that and say, if you're not going to do it, then we're not going to let you go forward with this eviction. So if you ever plan on doing this kind of an eviction, as long as it's allowed under state law, you really need to meet it.
That's very well said too. SB 567, which I did a video on that, it added more hurdles, more hoops to jump through for the substantial renovation termination of tenancy. And the reason it was passed is because there were landlords taking advantage of it, saying, "Oh, I'm going to do a substantial remodel, get a renter out, barely put in a coat of paint, and have it back on the market." So that's unfortunately the bad actors ruined it, and now it's a much more strict process to actually do it. Kenny, you mentioned the jury trial on either side being able to ask for one. Would there be any reason for a landlord to request a jury trial?
There might be, but generally speaking, jury trials are longer. They're more expensive. They're a lot more tedious. Bench trials usually will take about 1 day for these kind of cases. Jury trials, you're looking on average maybe 2 to 3 days, maybe even 4 or 5 days. So, long story short, generally speaking, landlords do not want to go forward with a jury trial because it's more it's cost effective to do a bench trial.
Yeah, but again, as you said, if the tenant says they want one, the landlord can't say, "Nah, we're not going to." You got to give them their rights. Okay, so John Galt Forever. I don't even know what he's asking here, so you guys have to do this. Can you explain the process and how to win Delta Motion to quash service from both sides? You guys are grinning because you know what that means. I have no idea what he's saying.
It's fun. It's fun.
What does it mean, Zach?
So this is a case from the 80s called Delta Imports. It said that you could use a motion to quash. That's a procedural device that challenges the service of the summons. They said that you could potentially use it to be akin to a general demur. Then there was a case also in the 80s called Borsic that said you can't do that. That wasn't resolved until just recently in a case called Stansel. Stansel said, well, maybe you can do it. You should only be using this. Don't use this to just delay your case. You can only be using it if the lawsuit that they're filing really isn't an eviction. So let's say I file a lawsuit and it says, you scratched my car while I was parked on, I don't know what, on, Beverly, I was parked in Beverly Hills. You scratched my car. Here's a 5-day unlawful detainer summons. You could use Stansel and Delta Imports to quash the service of the summons because it's the wrong summons. It should be a 30-day summons, not a 5-day summons. People will sort of abusively use a Delta quash motion to just buy time. So the normal way that you do that is you file your Delta quash motion, it gets denied, you take it up on a writ of mandate, that gets denied, but you're buying time. Don't do that. Don't do that. If you're on the landlord side, you'll want to know that motions to quash need to be made within 3 to 7 days of the filing. You need to have a hearing. And so that can be good grounds to advance a hearing date. You want to go as fast as possible. If you're a defendant and you're filing a Delta motion or a Stansel motion, you're probably just looking to buy time. So as far as like winning a Delta motion, unless the facts are really, really, really bizarre, like they were in Delta, where it really wasn't an eviction case at all, and somehow this guy got his hands on a 5-day summons and served it. Unless you're in that kind of weird factual scenario, you're not going to win. You're just going to try and use it to delay. So don't do it.
I love that answer. I still barely know what you said,
Okay.
but you were so confident in it, and you know your stuff.
Long story short, you file UDs if it's a UD.
That makes sense. That makes sense. That was great though, and I love your citing case law. I mean, I love you guys.
It's a whole thing. It's a whole thing, and it's just don't do it. Don't do it.
All-nighters here. You're on time, all-nighter. Thank you. Last time he came at the end. He's gonna be driving. Yeah, don't just listen, all-nighter. Stay focused on the road. R. Stark is looking forward to the eviction of Joe Biden to be carried out on January 20th. Will that be enough time to get him out of there? I don't know. I think he's going to go.
It's not going to be an eviction because he's going to voluntarily leave.
Yeah.
So, I mean, unless someone's going to file a lawsuit because he's not leaving, that could be an eviction. But when someone voluntarily leaves, you don't need to evict them. You just say, see you later.
How would it need to be an eviction? Like, what if a president stayed too long? Could you evict a president?
I mean, from the White House, I guess you would have to serve him a 3-day notice or some kind of notice to tell him to leave.
Well, especially a past president, because a sitting president would be different. You wouldn't evict him, but a past president, I wonder. That will have to.
It's like an employee manager. Usually you don't need notice. You could just start the case on day one. But yeah, you would need to get a hearing date and a trial date and go fight about it. Yeah.
That would be an interesting jury trial. How do you pick that jury for the eviction of the president? Anyway, all right. So let's talk. I'm going to run by a scenario that I just dealt with actually yesterday. And I want to get your opinion on this. So I have a listing, and I gave proper notice to all the renters. This was our third time doing it. It's been weeks in between each. It's not like I'm there every day. This renter in a unit, the first two times I dropped the notice, no problem, got in. Renter was there to let us in, easy peasy. Yesterday, we're doing a walkthrough. I had given sufficient notice, it was like 72-hour notice, dropped the notice on the door, and the renter didn't show up to let us in, didn't let me know. We didn't have any other way to get into the unit. Is that grounds for termination of tenancy because they weren't there to let us in? What are your thoughts?
I would say not if they just did it once. You kind of want to have them not let you in multiple times. I get this question pretty frequently. People call our office and say, it's a similar fact pattern. Sometimes the tenant doesn't let them in, even though they're inside the house. Even then, I still tell them, well, you got to try a couple more times, because you want to think 2-3 months down the line when you're telling the story that just happened to a judge or a jury. How are they going to perceive it, right? So if you look extremely reasonable and they don't, then you stand a really good chance of winning your case. For example, Your Honor or members of the jury, I gave this tenant notice, and I followed the law. I gave them 24-hour notice. I showed up. They didn't let me in. That's fine. I did it again and again. And then on the fourth try, I contacted my attorneys, and then we gave them notice. And again, they still did not let me in. So come on, right? But if you just go off of it just one time, I think you kind of look ridiculous. And, what if they just forgot or they were somewhere else? Yeah,
that makes sense. And then would you guys would want to serve something as well? It would be, what would it be? Like a 3-day cure quit type of thing? Yeah.
The way that we frame it out is we always like consent, and we always like it when parties get along with each other, because that's just what it should be about. But when someone says, well, I'm not going to let you in, you could serve another 24-hour notice minimum and see if you could work out a different date. And if they reject that again, then at that point, you could just serve a 3-day performer quit. And you say, okay, look, on this date, we asked you to let us in for this reason. You said no. We worked with you. We got you a different date. You said no again. And then now, we really need to get this done here. We're going to serve you what would otherwise be just a breach or a perform case. So it'd be a 3-day performer quit case saying, you need to let us in on this date, or else we're going to do the eviction based on the fact that you didn't let us in on the previous dates.
That's great. And I think too, it would be somewhat relevant based on what the reason to go in. Like if there's a massive leak and they're not letting us in, whereas this was just a walkthrough, there was less urgency, even though I did everything right. So
I think, Christian, you don't need notice to go in for emergency repairs. You could just
but if good point. So if there's an emergency and they won't let you in, then
just go in, break the lock, go in.
Yeah, especially for an emergency. All right, so I appreciate that, guys. That's why I set this up. Okay, we can all go. No, I'm just kidding. All Nighter says, yeah, he agrees. An established pattern of behavior is key. So 2025 is coming around the corner. What are you guys expecting for landlords and law and renters in 2025? Any big things on your radar? I know, for example, law has changed so that for renters answering an unlawful detainer action, they have 10 days now, 10 business days instead of 5. So that's one example. And I'm going to do other content related to some of the other laws. But what's on your radar? What are you guys looking at?
So recently, Huntington Park passed rent control. So you're probably going to see more of these in local jurisdictions. So this kind of goes back to what we were talking about, where the first question you need to ask yourself is, where are you? We ask it kind of ironically, but we really do need to know where you are, because that'll determine if you're under a rent control regime or not. So we expect probably more cities to follow through with passing their own versions of rent control. We're also probably going to see what we talked about earlier with the substantial renovation cases. Seems to be disfavored by legislators for whatever reason. And you're probably going to see either more stringent rules against it, or you're going to see them go away. So that's another thing that we're probably going to be seeing on that end.
Yeah, LA City's working to get rid of substantial remodel renovictions, as they call them, and I did a video on it, and there's fewer than 100 out of the 50,000 plus evictions in a given year in LA City. It's lack of rent. That the majority of the evictions are for non-payment of rent. So if LA City really wanted to focus on something, they'd focus on helping people pay their rent, not worry about wasting hours of time discussing renovictions. But what do I know?
That actually reminds me. You're probably going to see a lot more rent relief programs that are voluntary, not mandatory.
Okay.
So you're going to be seeing a lot more programs where it's either government funded or if it's funded by a charity of some kind. There have been a lot more of these programs. It's kind of hard to keep up with the number of programs because I've spoken with opposing councils and they said, "Oh, well, this one has funding," and I'm like, I talked to someone else and they say they don't have funding. It's like, "Oh, this is this 2.0 variation." And it's like, okay, well, let's see if they have funding for the rent on this one. So you're probably going to see a lot more of these rent relief programs that are still out there. But I think that we're past the point of where the government's going to say it's mandatory. Because during COVID, there was a period of time where you had to basically participate in this rent relief program before you could even do the eviction. And they got rid of that after COVID ended. So yeah, I still think the voluntary ones are still going to be around, and I think that they're going to be more of them, considering the way that California is going.
So by voluntary, you mean voluntary to the landlord to accept the cash?
Voluntary to participate in it, so you don't have to submit your application. Obviously, a lot of the restrictions with these programs is if you do accept the money, they're going to have provisions in there that state if you take the money, you can't evict them for that period of time, which
Yeah.
makes sense.
In
But
some case,
it's not
well,
mandatory.
the COVID funds, they were making you settle for some of the emergency rental assistance programs, ERAPs. They were requiring landlords to accept, for example, 30,000 as an absolute max, even if the renter owed you 50 or 60,000. So that's an example where if you took the money, you had to give up a bunch of money. So, Zach, what are you looking out for in 2025? Getting prepared for sharpening your lawyerly machete? I don't know. Whatever you sharpen, I don't know.
Yeah, my
Try to.
broadsword. Yeah,
There
my
you go.
brodiche. No, so I think that they're going to start moving in the direction. I believe New York has a right to counsel for tenants who are low income. So I think that's coming up. I think that more and more places are going to start giving tenants free lawyers in eviction cases, and then coupling that with the longer period to answer should cut down on the number of defaults, drive up the sort of cost and time of doing an eviction. And I think that's kind of where things are headed. And then, at the state level, I think there'll be more nibbling around the edges of evictions and, trying to sort of tinker, like you saw with the changes to the TPA, changes to security deposit laws. I think that, yeah, they'll start looking into some of the other no-fault eviction types and changing those to kind of be a little bit closer to LA, a little bit closer to Santa Monica. There are other places that might copy LA, which has the threshold limit. So it's possible that in other places, they'll require the landlord to float a certain amount of money to the tenant before they can commence an eviction. So if your tenant is only, let's say, $500 behind or something like that, landlord might, be forced to wait until that amount of money exceeds a certain threshold. And I agree that probably more rent relief programs will be on the way. I think that generally just a general tightening of the laws and restrictions. I don't think we're going to see, even though it was sort of an election in which, let's say, pro rent control people really didn't get a lot of what they wanted. I do think that at the state level and at the local level, they have a lot more backing than do people who are in favor of, let's say, deregulation or something like that. So that's, I think we'll keep trending in the direction of more regulation.
And Raphael, what are you feeling, bud? What's keeping you up at night? Or
I get to go last, right? So
yeah, well, I know part of what's keeping you up at night is you got a little one at home.
that's
She's
true.
getting big, but
Yeah.
but from a law standpoint, what's left to talk about?
I would say I have this. Maybe I'm being a little too optimistic, but I have a feeling that at the very least, the eviction process is going to get more. It's going to be more efficient. I'm kind of seeing they opened up a new courtroom in downtown that's going to hear unlawful detainer matters. So that raises the limit from 5 to 6 down, just 6 dedicated courtrooms that are only going to be dealing with these issues. And also, cases are starting to get prosecuted and actually get sent out for trial. So I'm kind of excited about that, to not have cases linger, because clients get unhappy when eventually, because we're the attorneys, all the blame always eventually falls to us. So, you know, if we can resolve a case really quickly, that always looks good. And I have this feeling that it's going to be better in 2025.
I like your optimism. That's
Yeah.
good.
Yeah.
So, what is it like in a courtroom? I know that's a very open question, but like, walk me through it. Like, I mean, is it sad? Is it? I don't know. Just give me an idea, like a day in the life of going into the courtroom, Raphael.
Yeah, so it's always the same way, pretty much everywhere. In every courthouse in the county, you show up, you check what number your case is on the calendar, you meet with the client, and then you find the defendant. You try to talk, see if you guys can come to a resolution, and the judges really encourage this. So if you check, as long as you check in, they won't call your case because they know you're outside trying to negotiate. So you'll try to talk to the tenant or opposing counsel if they're represented. If you can come to an agreement, literally in the hallway, either on a laptop or on a piece of paper that the court has, you would write down the terms, and then once you're ready, you go inside, you tell the clerk you're ready to have your case be called, and then you wait, they'll call your case, you'll finish up. If you cannot settle, you just wait until they call your case, and then you tell the judge you are ready to go to trial, or if you need a continuance, et cetera, et cetera. But it's pretty much the same everywhere. That's how it goes.
And then how often would you say that you negotiated out in the hallway?
Every single time.
But I mean that it's successful. Sorry. How often is it? Like half the time or less?
9 out of 10 usually.
Yeah.
9 out of 10 successful. It's the case for every kind of lawsuit in America. Most people want to avoid trial. It's very stressful. Things get heated. You could lose everything. You can win everything, right? But as long as you get a settlement that you can live with, that's, majority of people are reasonable. So most cases settle. Yeah.
Anything to add to that, Kenny?
Yeah, I think that something that stuck with me when it comes to settlement is a good settlement involves a position where no parties are happy, because it's going to be a give and take.
Yeah.
Both sides have to give something, and both sides are going to take something. That's what makes a good settlement. And when you go into that with that mindset, the likelihood of you settling your case is a lot higher. So I think that's a mentality that people, to a certain degree, should have, because trials are unpredictable. Trials can take a long time, and even getting to a trial might be longer than if you had just settled the case out. So a lot of the times, settlement is the preferred method to actually get a resolution, but you have to come to it with the right mindset. And I think that a lot of people, when they're in court, when they're in litigation, understandably, they come in with their guards up. I think a kind of fun way to put it is, a lot of people like to do what's called trial by surprise. They see a lot of, TV dramas, courtroom dramas, and they're like, "Hey, like I have this new piece of evidence that I didn't disclose to the other side at all, and I got you in a lie on cross-examination." It's the only part in TVs that you see. Very rarely does it happen in court. Very rarely. And if it does happen in court and there are attorneys involved, the attorneys didn't do their job correctly, because trials are supposed to be very routine. They're supposed to be very smooth and clean. And that's because all the parties are supposed to disclose their evidence to each other beforehand. And that's what makes it supposedly a clean process. So yeah, a lot of the times people need to come into court with the mindset of understanding their positions, their risks, and what it is that they're really looking for. I think that when you go into that situation, understanding what it is that you're looking for, you'll be able to get the result that you want. Unlawful detainers with evictions, they're going to resolve they're going to resolve two things realistically. It's going to involve money or it's going to involve possession. So once you start going into it thinking, oh well, I have gripes about the history of what they did to me, the emotional trauma, or I think that they harassed me, or I think that I'm entitled to something else. That's when you start, losing a lot of your steam. That's when you start losing out on the opportunity to actually reach a resolution that makes sense. So if you remain focused, if you remain, resolute in what you're looking for, possession or the money, or maybe even both, I think you'll get a better result.
So this also, if I'm can have a moment, I want to plug you guys, because this is why you need to hire a professional like you guys, because you know what is a realistic settlement outside the courtroom. You know what could potentially happen inside the courtroom. Yes, you can represent yourself on either side as in the unlawful detainer action, but why not hire somebody who does it all the time and knows the possible outcomes, and is going to work to bring this to a resolution that works for you? And I know it costs money, but it also saves you money to have an expert that helps you do it the right way and get it done as quickly as possible. So anyway,
And some
Zach,
of the,
what about you going to the courtroom, Zach?
Yeah, so I think that when you go to court, they do a good job of keeping everybody respectful. So you don't usually see too much theatrics. I mean, we've seen people get arrested, whether it's because they had an outstanding warrant or because they just screamed at the judge saying, you're going to have to take me out of here in handcuffs because I'm not going. But those are by far the exception, not the norm. The judge, they're very smart, compassionate, respectful. But you can go to court. You can go to court and just watch. If you're ever, I don't know, you ever get curious, you can go to court and watch most proceedings, and you see that it's just kind of a lot more silence and waiting, sort of administrative tasks, calendaring, what day works for you, what day works for you. It's a lot less than you might think, because you might have this kind of idea from TV that it's really a lot. It's not as bad as you think it is. So if you're ever intimidated going to court, I advise people to go watch, go check out how other people's cases are going and what that's like. And once you wrap your mind around it, you say, okay, this isn't such a bad and scary place at all. It's a place to be respectful. It's a place to be prepared, especially if you're going to go to court, you want to be prepared. But it's not anything to be afraid of, intimidated by. Everybody in the judicial system is a human being, same flesh and blood as you, me, or the next guy. So yeah.
But Christian, I kind of disagree with Zach. I would say on one note, I think it's very, very common for a lawful detainer courtrooms to. I've seen this, and it comes up at least once or twice a month, which someone fainting, someone shouting in the hallway, getting in a fight, or like Zach said, get arrested, or create theatrics to the point where the sheriff has to come from inside the courtroom outside in the hallway to see what's going on. Very, very common. Very common.
So All Nighter says he goes occasionally just to observe. But what I heard,
really quick, Christian.
Go ahead, Kenny. Add in, but
in regards to like the theatrics of it, people think that it's going to help your case. People think it's going to do something for your case. It doesn't do anything. I was in Compton this past week, and I did see someone faint, and she only fainted because she heard an offer from the other side that she didn't like. And I thought, okay, well, now we have to get paramedics here, and
was she
that
okay?
kind of. She was okay. And the thing is, a lot of the times, I don't know if this is indicative of our healthcare system or whatnot, but I have yet to see someone who wants to accept the ambulance ride out of the courthouse, and they say, "Oh, you know what? I'm okay. I'm okay."
Yeah.
yeah, it doesn't help your case. And I get it. It can be a very stressful situation. But you kind of need to go to court, you know, prepared, like Zach said, understand the situation, understand what can and can't happen. And if you go into with someone that's going to be able to help you out or tell you what's going to happen, then you won't be surprised. And you're not going to have moments where you might, pass out from an offer, or you might be, like shocked at something. So that's going to make you look a lot more reasonable. It's going to make you look a lot more professional, and people will want to side with people that are reasonable, prepared, and understand the situation.
So what I would like to do, if I could make this work, is I want to come see you guys. At least one of you guys in court. That would be fun. I can't film it there, can I? Am I allowed to film? No.
No.
Okay. I could just give my like play-by-play opinion, record it into a microphone or something. That would be fun. All right, so I think everybody's getting ready for Christmas. All we've got is all-nighter talking to us. We don't have many questions tonight. You guys answered those other questions well. So tell me about you guys and why I should hire you, the California Property Law Group, if I'm having trouble with my renter.
So one thing that I do want to point out, and I feel like I'm a broken record at this point, but I say this over and over and over and over again, is that if you're going to rent out property in California, you need to treat it like a business. You need to treat it like a business, because that's what it is. California is treating you like a business. And just like businesses do, they can fail. They can fail. And what that means is that if you don't treat it like a business, you will fail, and you might lose the property, and you might say, well, that's unfair, I can't do, it's like, why should I have to do X, Y, and Z? It's because California is treating you like a business, and if you're not going to treat it like a business, you will lose your property potentially. And that's the unfortunate reality. So when I ask certain landlords, hey, can you provide me a ledger, I'm still shocked at how many landlords either A, don't know what a ledger is, or B, say it's all up in here. That's not a good answer. That is not a good answer, because I've had judges come at trial and say, hey, where's your proof that this is the amount of rent that's owed? And then once you start saying numbers that don't make sense, or you misspeak, you look like you're not telling the truth, or you don't look credible. And then once your credibility is gone, you lose everything. You lose everything. The way that you look credible is if you have a ledger, is if you have a lease that outlines, this is what I'm asking for, this is what was paid, this is what wasn't paid, this is the number, that's how I got there. You look professional, responsible, and prepared. And that's what they're looking for. That's what they're looking for. It's, you need to show up prepared. And the way that you do that is if you treat it like a business, you have processes that are put in place, and that'll add on to your credibility. And credibility really is what's going to get you to the end.
And having like a tenant file, I know it's difficult for some people who have multiple units, but having a tenant file where you have receipts of all the repairs done, in one place, and all the communications. If you have some kind of a portal where you guys communicate, save that, right? Jurors love evidence. Whenever we finish trials, I always talk to them outside the hallway and say, hey, why did you decide on this issue the way you did? Almost always they'll all say the same thing: evidence. Like, you didn't have evidence, or you had evidence, right? So that's what they love to see. So you got to help your attorney help you keep the record.
And yeah, and I'm going to do some content on this, but when you have turnover, you're going to be required to have pictures now of the unit before they move in, whenever you do any repairs. So that's a prime example to what you're saying, Raphael, where you need to have some sort of file for each property. Otherwise, you're going to be in big trouble if you don't start getting organized now. And it's not like there aren't plenty of software programs out there. So, Zach, why should I work with you?
Yeah, I think that what we do is we guide people through a process that many times they haven't experienced. And you want someone, just like if you're going to go climb a mountain, you want someone who's been up that mountain. If someone tells you, I go up that mountain every day, I've been up there thousands of times, I can show you where people fall into the ditch. I can show you where people get stuck and help you avoid the things that you won't even know. There are questions that you won't even know to ask when you're going through the process. So you need someone, or it behooves you to have someone who can help you avoid those common mistakes. Because what you come to find out is that it's totally possible for you to get up this mountain, but it's also totally possible for you to fall off, right? So if you have somebody who can keep you on the right path, you'll find it's not that bad. It's not nearly as bad as some people. And if you go to court, you'll see them. I mean, unfortunate people who make mistakes, who didn't follow a law they never knew existed, who are completely ignorant as to the legal regime. Sometimes attorneys will make mistakes. But if the longer you spend doing it, the more times you go up that mountain, the more you understand the terrain and the better you are at getting people from where they are to where they want to go. So we've been fortunate enough to help a number of people, hundreds of people, thousands of people, get their properties back. We know what's up. We know the way up and down the mountain. So if you hire us, you get somebody who's done it before. And I think that, it's somebody who will help you, especially if it's your first time. We work with first-time clients every single day. So, but not, I don't like being not humble or whatever. There's lots of good attorneys. I think that we do a good job. But please.
You're the best. I tell people that. I come out and tell people that you're the best. So California Property Law Group, your landlord law Sherpa is what we've just heard from Zach. That's exactly what you've described. And then what you said, helping people avoid the common mistake is exactly what you do. And it's also the uncommon mistake.
Yeah.
There are errors that can be made that only people who are in the courtroom, as much as these guys are, will know how to avoid those. And just because somebody passed the bar does not mean they should be representing you in landlord-tenant law. That's the other big thing. You absolutely need a specialist, and you guys happen to be the best specialists. So a couple quick things, all-nighter. Confirming what you guys said, real estate investing is a business. Managing inanimate properties, a balance sheet, and real-world people. Well said. And then where are you all at today does have a question that we can dive into before we go. Good question. Can you ever reset rent back to market rate after the 2-year owner occupancy eviction? So this would be termination of tenancy, the no fault excuse being owner move-in. The owner legitimately lives there, does everything they need to do for 2 years. Now, if they move out, can they charge market rent?
So you're going to want to take a look. So this is, I'm assuming, because this is 2 years, that we're talking probably about LA City. The Costa-Hawkins Rental Act, state law, says that when you have a vacancy, the property becomes vacancy decontrolled, meaning that you can raise the rent to whatever you want, unless the property becomes vacant because of certain kinds of evictions. One such eviction is an owner move-in. So that means that the property would continue to be vacancy controlled. So the idea is that after you move in, you're supposed to put the new tenant in there at the rent that the old tenant was paying plus adjustments. One way that you can get vacancy decontrol again is by having that next tenant move out. Then I think Costa-Hawkins says you should be able to raise the rent to market. LA takes a different approach. If you check out Los Angeles Municipal Code, I think it's 151.06 is where it is. They say that if you do an owner move-in and you put in a new tenant and then that new tenant leaves, it still gets vacancy controlled until the next tenant leaves, because inevitably what people would do, they would do an owner move-in, say, oh, wait a minute, it's vacancy controlled. Let me just have my friend stay there for a month. Then when my friend leaves, what happens if the friend doesn't leave? Call us. But if the friend does leave, then you could raise the rent to market. So LA says, well, who's going to have two friends, I guess? Who's going to do that 2 times? I think that's preempted by state law. I don't think that survives contact with Costa-Hawkins, which says that if somebody voluntarily vacates, the unit becomes vacancy decontrolled, but that's what LA says. So yeah, I believe I know there's a rent adjustment commission regulation on this. And I think if you check out Los Angeles Municipal Code, I think 151.06 should answer, 06 or 04 should answer your question.
So I think, and thank you for the detailed explanation and the nuance in it. And like Kenny said, it depends where you are on everything for any of these questions. It also depends what it is, what type of property matters as well. But I think a better practice would be don't attempt to use owner move in to reset your rents. Just use it to move into your property and live in your property. It's probably a better practice. But
Yeah, I've had certain potential clients or landlords who would call in and say, "Hey, I'd like to move into the unit," and then I'm like, "Okay, cool. Let me ask a couple of other clarifying questions." I ask, 3 questions, like who's moving in. They say, "Oh, myself," and it's like, "Okay, how many units are there?" "Oh, there's 4." It's like, "Okay, are they vacant?" It's like, "Yeah, they're vacant except for one." It's like, "Okay, so why do you want that particular one?" It's like, "Oh, because the tenant's in there." And it's like, "Okay, what's wrong with the other 3 units?" It's like nothing. So yeah, we all see what's going on here. The point of this is that you're moving into the unit because you are moving into the unit, not because you're raising the rent, not because you think the rent is low. That's the reason why you're seeing a lot of backlash and a lot of back and forth with legislatures who are saying, "Hey, like you guys can't be doing this just to raise the rent." So you're going to start seeing a lot more legislatures who are trying to push back on otherwise regular evictions because a lot of landlords are saying, well, I want to raise the rent on these units and I'm going to do whatever I can to raise the rent. But if you just take what the just cause reasons are for eviction at its face value, you'll be fine.
yeah, and you can always use cash for keys in that example you just said. Like, offer them money and see if they'll move out. That's a legitimate way to raise the rent. You can buy them out. And there's nothing that prevents it. Even rent controlled units, you got to make sure you follow the right steps and do it correctly, but you can buy people out. All right. Well, we're going to end it a little bit short. I know we got to go do our respective holiday shopping and festivities, but I want to thank you guys so much. We've been doing these for a while, I think over a year, maybe like 2 years now. I learn something every darn time we do these. I love this. And you got to promise me, raise your right hand. We're going to continue to do these through 2025, right? All right. Zach's in.
I do.
Kenny's in.
I'm taking the oath.
All right. I appreciate you guys. Have an amazing holiday season. We will let you know when we're going to have our next ones and get those calendared for 2025. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we can't